Hey, John, how are you today?
Good, Elliot. We're recording on April Fool's Day, but it is not April Fool's. It's the fourth week of the war against Iran. Obviously, there are things related to sanctions and national security that others are covering, but wanted to mention that. A couple things in the U.S. to start with. CNBC is reporting that Bank of America has agreed to pay $72.5 million to settle a lawsuit filed by a victim of Jeffrey Epstein. The settlement is part of a broader effort of several other cases that have been brought. It covers all women who were sexually abused or trafficked by Epstein or connected to his sex trafficking venture between June 30th, 2008 and July 6th of 2019. The settlement amount for class members will be determined, according to the story, by various factors, including the severity and extent of alleged abuse or trafficking. There's been other settlements I think we've reported in the past. So that, again, reported by CNBC just the other day. Unrelated, but another case regarding a bank, Capital One won at least the initial round of a case. This was a case dealing with the account closure suit brought by Trump's business entities. So a federal judge in Florida has dismissed a lawsuit brought by Trump's business entities that accused Capital One of closing hundreds of accounts after the January 6th Capitol riot. It does leave, according to the report here, the door open for plaintiffs to try again if they revise their complaint. The district judge granted Capital One's motion to dismiss during last Friday's hearing, ruling that the complaint was, quote, deficient, unquote, but again allowed the Trump entities time to seek limited evidence and then amend their claims. Important case on the whole issue of reputational risk and account closures, debanking. So this is going to be closely watched, certainly by our community.
Indeed. So, a couple things overseas. One is that, and we've reported on this, there's some key milestones in the Australian update to its anti-money laundering and anti-fraud regime beginning this week. Businesses that are newly covered under the expanded regulations can now start enrolling into the process through Austrac's online platform. And their chief executive, Brendan Thomas, was quoted as saying that the reforms are about closing long-standing gaps, lifting protections across the economy, and making it harder for criminals to hide, move, or enjoy the proceeds of crime. So the actual obligation to report kicks in July 1st. The folks that are being brought in include lawyers, accountants, and real estate agents. So again, that whole group of gatekeepers, a number of whom are not covered here in the US. But these groups are covered in the UK. They're covered under AMLA in the EU. So it's interesting how the US continues to be a bigger and bigger outlier with regard to gatekeepers. And staying outside the US, the UK fined Apple for breaching Russian sanctions. It was about a 500,000 US dollar fine. An Apple-related company made funds available to a designated sanctioned person without getting a license. This goes back to 2022. Apple made a statement that said they follow the laws in the countries where the company operates and that it takes sanctions compliance extremely seriously. Interesting to see how even a big company with lots of resources can get tripped up. And then the UK issued sanctions against what it's describing as the largest scam center in Cambodia. And we've talked about these large scam centers in Southeast Asia. And so this is the latest attempt by the UK to disrupt what is it called a fast-growing network of scam centers in Southeast Asia where workers end up confined in guarded compounds and forced to commit online fraud. And it noted that this particular scam center had capacity for 20,000 traffic workers.
Wow.
Yeah. I'll shift it back to you. I know FinCEN had a couple things.
Yeah, just quick before we go to that, just wanted to
Yep.
mention something else that I've just seen and I haven't gone through it yet. But OECD, their working group on bribery in international business transactions, has issued their 2025 annual report. It's a pretty short document. It's about 30 pages long. And OECD has done a tremendous amount of work over time dealing with this issue. It breaks out how the working group is comprised. They've had meetings in March, June, October, and December, then put the report together. It's always useful to see issues regarding what they're calling foreign bribery issues. And like I said, they walk through the process, outcomes of the meetings. Law enforcement's involved with these exchanges. They're very supportive of global dialogue. And then just in terms of how they monitor the anti-bribery convention and recommendation of OECD, they go through four phases. They evaluate the adequacy of the country's legal framework. The second phase is whether a country is applying the legislation in practice. Third phase is focusing on enforcement and what they call cross-cutting issues. And then finally, the enforcement tailored to country-specific needs and what are unimplemented recommendations, that sort of thing. So again, the OECD, obviously well-respected organization, anti-bribery and other things that they do. So that's available on their website.
I saw that report. Just to fill a little more background for our listeners, the working group, as you mentioned, comes out of the convention that was put in place, but that convention goes back to May of 1997. So this is work that's been going on now for almost 30 years. The convention's purpose is its focus on disrupting the supply side of transnational corruption. You and I have talked a lot about corruption in the last 12 months, and I think this is something that I don't want to say gets lost, but it's important to remember that it's a mosaic of things by a lot of organizations, but this is a very important one. And I think the report is worth people's time.
I agree. I teach a class at George Mason, a graduate class on money laundering, corruption, and terrorism. And this is a focal point of at least one of the classes. We talk in depth on corruption issues, from how the U.S. handles the Foreign Corrupt Practices Act to issues like OECD and the like. You mentioned FinCEN, two things to reference. They issued a notice of proposed rulemaking to pay whistleblowers. So it's a notice, you get a chance to comment. The proposal lists procedures for whistleblowers to share information about potential violations. The violations they're focused on is fraud-related ones or sanctions programs, and they say several other laws. The eligibility criteria for making awards of 10 to 30% of the monetary penalties, whose tip leads to, quote, successful enforcement by Treasury or DOJ, and protection for those whistleblowers. So that's one item that FinCEN released last week. And then the other one was an advisory on healthcare fraud, targeting Medicare, Medicaid, and other federal and state healthcare benefit programs. Again, the advisory is on FinCEN's website. It gives you money laundering typologies and red flag indicators, and strongly encourages FIs to voluntarily report suspicious activity to FinCEN, which of course they do when they see it and they notify it. So that's an obvious statement, but that is in the advisory as well.
I thought it was interesting that the first typology was use of straw owners and shell companies to register as healthcare providers and suppliers. And I thought it was interesting that it was at the top of the list, since the recent changes to the Corporate Transparency Act have reduced our ability to figure out who the real owners are of shell companies. We can pay attention to the typology, but I don't know that we can do a lot about it.
And related to that, a couple of days ago, a letter was sent to the Treasury Department from several senators and Maxine Waters on the House side. And the context of the letter is the concern that you just mentioned. And this is a quote from that letter. Treasury has taken this approach, meaning what they believe is gutting of the CTA. Despite ample evidence that criminals and foreign adversaries use shell companies or opaque corporate structures in the U.S., this includes Sinaloa cartel operatives, Iranian sanctions evaders, and those stealing technology for China's military. They also expressed particular concern regarding Elon Musk's involvement in, they say, the gutting of the Corporate Transparency Act. Again, quoting from the letter, new reporting has revealed that Mr. Musk uses a network of dozens of secretive companies, potentially the type of entities that under the CTA are required to report ownership information to the Treasury Department. It would be deeply troubling if Mr. Musk intervened in any way to limit those transparency requirements. So that letter was just sent. There has not yet been a response from the Treasury Department.
I saw an interesting thing on the website The Hill, and it is an opinion piece by a fellow named Mark Rechtenwald. He is the former Chief Justice of the Hawaii Supreme Court. He was an assistant U.S. attorney earlier in his career, and he has a very interesting piece, and it has to do with the recent announcement by the DOJ that they're issuing a proposed rule that would allow the DOJ to override state legal requirements. You and I both are lawyers. We each got our law license from a particular state. We're subject to the disciplinary rules of that state. Each individual state has its own ethics code, although many of them follow the ABA model code, so they're very similar. There have been a number of judicial opinions from the federal court recently complaining about unethical behavior, failure to follow court orders, and things like that of DOJ lawyers. The DOJ is now trying to supersede state ethics enforcement rules, even to the point the proposed rule has a provision that DOJ could take action against states if they didn't cooperate in DOJ investigations of their own employees. So I think it's worth a read. There are a number of citations to previous cases, as well as a piece of legislation that's been around for quite a while that was put in place by Congress, according to the author, to stop just this type of activity. I've always thought as a lawyer that I was responsible for doing the right thing, even if it was the uncomfortable thing. And I think that's true of my friends and colleagues over the years who I know worked for the Justice Department and felt the same way. This is just a bad idea.
The last thing I want to mention, we have posted several podcasts related to the very topical and current issue of the mutual evaluation of the U.S. from FATF. The podcasts have been interviewing people in the humanitarian and charity space and their ongoing concern about them being either de-risked or having problems getting financial access, in part due to the following of Recommendation 8, which is the terrorist financing recommendation, but also the laws and regulations dealing with money laundering and anti-terrorism. The one thing I wanted to mention is the United Nations Human Rights Council issued a very similar statement late last week for the evaluators to consider. This came from Professor Ben Saul, who's on that council. And basically, he has urged the following. He encourages the FATF assessors to rate the U.S. as, quote, partially compliant, unquote, on Recommendation 8, concerning efforts to address the terrorist financing risk of nonprofit organizations. It's a short 2-page document, a number of the concerns that he lists, and this is dated March 26th. In practice, regulators of financial institutions still tend to treat NPOs as high risk, despite official guidance, with negative impacts on their ability to freely operate, and applicable strict liability offenses can result in disproportionate penalties. And there are other ones there that are arguing that some NPOs are being targeted. So the bottom line is going to be very interesting. We've talked about this before. The in-person evaluation period is now over, and so the report now will be crafted. We believe that report will see the light of day sometime in October, but we'll continue to follow this.
Anything else, John?
That's all I have on my end. You want to mention what we're doing for our April webinar?
Yes, we're going to be talking about scams targeting elder abuse and sexploitation. It's going to live stream at 1 p.m. on April 23rd. We're lining up, as usual, a great group of experts. And John, I know you're going to moderate that. Any other things that you have in the pipeline?
I won't mention the guest just yet, but somebody from one of the industries that have AML obligations that we haven't talked to in a while, has been given permission to sit down for an interview. So we're going to work on that most likely during the Easter break in the next week or so. And that will post a week or two after that. So we're efforting that. And I forgot to mention, OFAC did do one other thing that I know you saw and identified, and they issued a guidance yesterday, basically, on sham transactions and sanctions evasion. So it is a 5-page document. It gives some examples of sham transactions and some direction to all of us that see these, what they're calling commercially unreasonable transactions, and what our requirements should be to deal with that.
I did see that, and worth a look. So, John, you have a good rest of the week, and I will talk to you next week.
Stay safe.
You too. Bye-bye.